Your Honor, I don't see opposing counsel on. There she is.
Very good, Mr. Perkins. I saw the same thing, and Ms. Lynn has shown up in the virtual courtroom. So we're happy to have you both in here. And Mr. Perkins, you may proceed.
Thank you, Your Honor. May it please the court, I'd like to reserve 1 minute for rebuttal.
Very good.
The appellant is Rotor Holdings, and they have a rent-to-own program for residential real property. The program is very simple. Participants select a home from Rotor's inventory that they would like to rent with the option of buying. They sign a lease and an option to purchase. If they make their rent payments on time, those payments are credited towards the purchase price and the closing cost when they exercise their options. Appellee approached Rotor and they spoke with a gentleman named Mr. Maximum. He was the then CFO of Rotor. They alleged that Mr. Maximum promised them that he would loan them the money to close on the home when they decided to exercise their option. After being in the program for approximately 8 months, they approached Mr. Maximum and they sought to close on the loan and asked him, or close on the property and asked him for the loan. They allege, and at trial, they showed that at that time, Mr. Maxim said, "We don't have a loan for you," and referred him to.
That gentleman never testified. Is that true?
That is true. The current CFO at the time of trial testified, yes. But the appellees testified that Mr. Maxim said, "We don't have a loan for you," and referred him to a mortgage broker. And we're here on competent substantial evidence, so I understand the standard of review, and so that's what the appellees testified to.
So why wouldn't that fit the test?
Well, it would, but they bring a claim for fraudulent inducement, and for fraudulent inducement, they have to prove at the time that promise was made that there was no present intent to make the loan. And there's just simply no evidence to show that at the time this promise that the court found was made, that there was no intent to carry through with that loan. And therefore, their claim for fraudulent inducement fails.
But there wasn't any damages awarded for fraudulent inducement, really. It was based on the breach of contract. Didn't the trial court just do the math and award the $22,000, which is the amount that the appellees paid over and above the rental amounts?
Well, they, under count one, which was fraudulent inducement at the inception of the transaction, count one, that's what they awarded.
Okay, but that's breach of contract also, correct? Maybe the court maybe mislabeled it or didn't hurt your client no harm, no foul is the way I'm looking at this. Is that, didn't give any extra damages there's no punitives or anything like that for fraud and inducement.
Well, Your Honor,
what were the damages awarded for fraud and inducement? I'll ask it that way. You tell me.
$22,340.
Okay. Is that the same amount that was paid over and above the lease payments? Is that the amount that was paid on top of the lease, correct?
Yes, for the option and for the rent payments more than what the trial court found.
Here's my next question. Didn't the judge find that under Chapter 83, you can't use the eviction process on a rent to buy contract such as this?
That wasn't the judge's reasoning.
It was in the rehearing. It was
right.
In the denial of the rehearing.
Right, but that wasn't the reasoning of the final judgment. And the judge, quite frankly, that issue is a little bit more complex because with an option, that's different than a deposit. And that.
So you're saying the judge might have missed the mark on that, but it's not before us because
Yes.
It came up on a rehearing for the first time.
Yes, Your Honor.
Okay, move on, please.
Yes, and so the breach of contract was not pled, it was not defended, it was not tried. Fraud and the inducement was what we tried at the trial court. In addition, under count 3, the trial court found fraud and the inducement, or found that there was an unfair and deceptive trade practice because Rotor had no intention of actually selling the property to the appellees. But once again, there's no evidence to show that at the time the transaction was entered into, that there was no such intention made. For the second count, which was—
No, but they did say there's 119 eviction cases, and they entered a couple in evidence
Yes, Your Honor. And
under this plan that was instituted by your clients.
There was 119 cases total. Some of those were quiet title and business transactions. It wasn't calculated exactly how many were evictions, but nonetheless, yes, Your Honor. And for my last argument, where I said there was no competent substantial evidence that there was more than 100 cases, I recede from that because I've read the record very clearly. The judge did have a docket, appears to have had a docket in front of her when that testimony was going on. But there was no indication of how many of those were eviction cases. But for count 2, which is fraud in the eviction proceeding, the court had no jurisdiction to entertain that count because the eviction proceeding occurred in the county court, and the fraud in the eviction proceeding was brought in the circuit court. And so there's no jurisdiction for the circuit court to adjudicate that claim. In addition, the damages that were awarded were lost property as a result of this alleged fraud in the eviction proceeding. The property, there was testimony as to the value of some of the property, not all of the property, and the testimony was as to the purchase price of that property, not as to the present value.
But the testimony was that the property was purchased about 2 years before it was allegedly destroyed or damaged or lost, let's say, and that was about $44,000. The judge only awarded damages totaling $32,000. So the judge cut down the claim damages by some amount. And theoretically, a judge could have used the purchase price or the value within 2 years of the loss, but the judge didn't do that. And you had no countervailing evidence on worth or damages, correct?
No, Your Honor. Our position is they have not proven the value of the.
No, I understand.
Mr. Perkins, let me go back for a minute to count 1 and count 2, the fraud. Obviously, you're rarely going to get direct evidence of fraudulent intent. It's all going to be proven by circumstantial evidence. And so couldn't the trial court consider the entire course of dealings between the parties to ascertain Meshkaran's intent at the time of they entered into the contract? If you look at the entire course, which included this statement, I guess 2 days after receiving the rental money, oh yeah, don't worry about that eviction proceeding, that's going to go away. And yet they show up, Meshkaran shows up at the house with the sheriff to boot them out the door. Doesn't that factor in? Isn't that circumstantial evidence of intent that the court could attribute to Mr. Meshkaran generally?
Okay, as to count 1, no, I would disagree, because the intent that's relevant is the intent at the time of the inception of the transaction.
I understand that, but couldn't that sort of be, again, inferred by the entire course of dealings between the parties? I'm not saying it's direct evidence of what his intent was there, but it suggests that there's a scam going on broadly. And is that something that the trial court could consider, absent any evidence to the contrary, in trying to determine his intent at that time?
Your Honor, I think these are 2 completely separate incidences, and I understand what you're saying. I appreciate what you're saying, but I think that the circumstantial evidence would have to be related to Roeder or Mr. Maxim's intent at the time. And I don't think that a conversation regarding the eviction proceeding would be competent substantial evidence to support a finding that originally that there was no intent to even proceed with the transaction. And so, I can agree to disagree, but that is the position. And if that was the case, I realize that competent substantial evidence is not a quantity, but it is the type of evidence that a reasonable fact finder would use to arrive at an inference to infer a fact. And that, in my mind, does not rise above a scintilla of evidence.
Okay, you think it's too much of a reach, right? And
It
basically,
is.
yeah.
That's
Okay.
that is our position, Your Honor.
Okay.
And so at the end of the day, what we're asking the court to do is to reverse on counts 1 through 4. Count 1, no competent substantial evidence. Count 2, no jurisdiction and no competent substantial evidence. And count 3, there would be no competent substantial evidence that there was a fraudulent statement made that would give rise to unjust or unfair and deceptive trade practices. And then as far as the unjust enrichment count, because there's a contract between the parties, that count just fails as a matter of law. I will reserve the remaining time, or my remaining 1 minute, for rebuttal. Thank you.
Very good. Thank you very much. And Ms. Lynn, we're ready for you.
Thank you, Your Honor. As the court was pointing out, this is a fact-intensive case, and of course, the trial court is in the best position to make the determinations as far as the credibility of witnesses and the evidence that they take into consideration. And with the entire case is essentially a case about an ongoing fraud from the beginning, from the commencement.
When you talk about fraud, that raises a question. Was there any pretrial depositions done of the landlords or the people who had this plan in place?
There were not, Your Honor.
Okay, because it seems to me there may have been a Fifth Amendment right to remain silent, because this has all the earmarkings of a criminal enterprise or a RICO violation or something, when you talk about 119 cases. And I'm not surprised the gentleman on the other side didn't testify because he didn't want to be anywhere near an oath. That's just my speculation based upon the overall record. And now we're hearing complaints that there was no fraud. What's your response to that?
On
their part, that your client didn't prove fraud in the inducement or any sort of fraud, because it's just an eviction after all.
Yes, Your Honor. Basically, my clients had testified, and there was no.
Your client only spoke Creole, so there's a kind of a language problem here to begin with, right?
My client.
An interpreter in this case.
We did have an interpreter at the trial, but we did that in the sake of being prudent, just to be sure that the appellees understood everything that was said. They do speak English, and the court did note, often they were answering before the translator was even complete. But I wanted to be sure that with the legalese and the issues that we'd be discussing, that they would be certain to understand everything when they were dealing with.
You can move on. You can go past all that. That's strategy. I get it.
Thank you. But the evidence that they presented was uncontroverted as far as the statements that were made to them, the promises that were made, and the fact that none of those promises were contained in any of the documents. Going to specifically to the fraud and the inducement problem that opposing counsel has suggested. The facts have to be taken as a whole. And what happened from the beginning was that he said he was going to make a loan, when in fact it turns out that this company was not in the business of making loans. I did point that out in my answer brief, that the witness who was the COO who began working there in October of 2015, which was 2 years after the events. He had testified that to his knowledge, Rotor Holdings had never given a loan to anyone or ever offered a loan to anyone. And that was one of the things that I had pointed out as far as one of the facts that support this allegation, that there was no intent to offer a loan and that the promise was made outside of the contracts in order to induce the appellees to sign the contracts and pay more money. And at every point,
Ms. Lynn, what distinguishes, what evidence is necessary to distinguish between an erroneous statement and a fraudulent statement? And why have we reached that level here?
I would again suggest that it has to be inferred from the circumstances and evidence taken as a whole. From the beginning, this Max, who my clients had dealt with, was the COO or president of the company at the time. So it is a reasonable inference to know that he would have an idea and know how the program works and what is offered under the program. So that being the case, there never having been a loan offered, and the testimony of the COO at the time of the trial that they're not even allowed to do loans or offer mortgages, they're not licensed for that, are facts from which the court can reasonably infer that this was a lie at the time that it was made in the beginning.
Well, okay, go on, I'm sorry.
Thanks. And, you know, some of the part of it, of course, will also go to the events that followed. And basically what happened after they were told they could not get a loan, Mr. Max suggested that they had to be paying more towards the purchase price and they had to go and find their own loan. My clients, not wanting to lose the large sums of money that they had already put towards the home, went to start looking for a home loan and started to pay the amounts that Max demanded. In addition, understanding on their part that those amounts were still going towards the purchase price and at least bringing the purchase price down and of course bringing them closer to obtaining a loan. Unfortunately, Max took their money and he went and he filed an eviction lawsuit against them. And when they asked him why this was done, he said it was a mistake. There's no reasonable explanation for why Max would have told them that that it was a mistake, that he was stopping the eviction and throwing their belongings out and not even giving them the opportunity to retain their belongings or obtain their belongings. So throughout the course of the eviction, he told them that they didn't do anything. That way he was able to push the case to a default. That way he was able to get his default final judgment and execute his writ of possession and throw them out of the home. So that explains, in the entirety of the facts goes to that claim for fraud during the county court eviction proceedings. Additionally, I wanted to note that the court did have jurisdiction over the fraud claim arising out of the eviction case because my clients were, even though there was fraud against the court, well, my clients claimed and what the award was based on was fraud on my clients, which is all of those lies that Max told him about the eviction case and about how he's going to stop the eviction case.
You're not trying to collaterally challenge the judgment in the eviction case, right?
It was a separate, no, Your Honor, because in fact, after the judgment, the case was reopened and the case was voluntarily dismissed. And it came up an argument that, of course, a voluntary dismissal is absolutely takes care or gets rid of a case. There's nothing further to be done and you can't reopen it after that. So that's correct, Your Honor. We're not trying to attack the judgment. In fact, it was just much too late to do that anyway. The deed had been done. They'd been thrown out of the unit and their belongings destroyed. So that's why it was brought instead as a fraud claim with as a fraud in the eviction against my clients with damages in the amount of the value of the belongings that were thrown out that they lost. And to that argument, as far as the values of those items, my clients and their additional third witness, which was the brother-in-law of Miss Volmy, three adult people who lived there and had been the purchasers of the objects that were in that home. They testified as to, in some circumstances, they testified as to how much they purchased the objects for. They did testify that they purchased the objects shortly before moving in. And at the time of destruction, based on the timeline in the case, it would be about 2 years later, as the court had suggested. They showed pictures, and the court had the opportunity to view the color photographs and to hear their testimony as to the values of all of those items. The court is not required to get an exact value or delineate the exact value of the items, as long as the court has a reasonable basis for determining those values. And the idea, of course, of damages is to make the claimant whole again. And based on the evidence that was presented to the court properly made the determination, as it did, as to the damages because of the values, as my clients testified, along with their witness and with the photographs that were presented. And of course, opposing counsel had the opportunity to cross-examine them on that as well. Therefore, there is substantial competent evidence to support the amount of damages due to the fraud in the eviction case. As to the unjust enrichment argument, Your Honor, it's when I adjusted in my brief, I said that the original 3 contracts had been expired and therefore there's no contract going forward. I sort of maintain that argument, but I would even take it further back to say that because an agreement requires a meeting of the minds, it would seem that at no point did these contracts really contain the agreements that should have been the meeting of the minds. It seems, or at least it seems clear, that these contracts contained all of these requirements and specifically said that this deposit would be forfeited, while Max, and even as the witness at the time of trial, the COO, explained how they tell applicants about the promises that they make. They promise that they can extend their contract for a year. They promise that they can even put that money towards a different house. They promise that that they're going to work with them. But at the end of the day, the contract just says that they forfeit the deposit. So with
the judge found it was subsumed, right? The damages for count 3 was subsumed in count 4 anyway. So it's correct. No harm, no foul if there's a legal faux pas as far as analysis goes.
Correct, Your Honor. I believe it was 1, 2, and 4 that they were subsumed, the fraud charges and the unjust enrichment. It was the fraud and the eviction, and the damages as to the values of the property was the only other one outside of that.
That's fine. Proceed.
Okay. As to the unfair and deceptive trade practices claim, Your Honor, it seems clear based on what my clients had suggested or testified that Max had told them, the lies that he told them to try and get them to sign these documents, was similar, in fact, to the testimony that was given by the current chief operating officer. You know, in fact, he explained to the court at length on all of the promises that he does make outside of the contracts. And there's nothing to take away from the fact that at the end of the day, the contracts don't contain any of those promises. And at the end,
well, the testimony does not match. I mean, testimony on both sides is pretty consistent as to the undisputed facts. There's a disagreement as to the conclusions. They say it doesn't support the judgment. You say it does. That normally is a credibility thing that we would defer to the trial court. I'm assuming in his 1 minute remaining, he's going to say there's not enough to support the judgment, something along those lines. Okay.
That's my understanding.
Is there anything you want to add on that question, if you want to call it that?
I would agree with the court on that, and I would state that taken as a whole, all of the evidence put together, that the court had the opportunity to take into consideration, that there's certainly competent substantial evidence to support the court's findings, Your Honor.
Thank you.
Very good. Are you still have a few minutes if you wish to use it, Ms. Lynn? I couldn't tell if you were pausing or you're done.
I'm satisfied. If the court has any further questions for me, I'm prepared to answer.
Very good. I don't see anybody asking questions. So Mr. Perkins, you have your minute for rebuttal.
Thank you. Your Honor brought up RICO and why Mr. Max didn't testify. At the trial, it was indicated that Mr. Max was no longer with the company, hadn't been with the company for years prior to the trial. And I realize that Your Honor said it was speculation on your part, but I'd like to.
He could have been subpoenaed, whether he's with the company or not. They're talking about statements he made that were obviously against the company's interest. He could have been subpoenaed whether he was currently employed or not just because he might be the subject of a RICO or some other criminal conspiracy count.
It's my understanding that he was beyond the subpoena powers of the court.
All right. Well, that's that question.
As far as the 119 cases, I realize that sounds like a lot of cases.
You're not appealing. The court overruled your objection. A few got admitted to evidence, I think, from Naples, but there's no appeal of that ruling being erroneous or not. That came in evidence. End of story. Correct?
Correct, Your Honor. I'm pointing out that the size of that number, when Your Honor said that there was a lot of cases and that this was a RICO or a scam, I just.
Oh, okay. Well, you don't need to refute me. I'm not the DA in this case.
I realize that, but I don't want to, a case over, a trial over this to turn into something that quite frankly.
Well, I don't know what's going to happen. I personally don't know what's going to happen. I threw that question out to offer a possible explanation. I did say it was speculation. Now you told me he's outside the jurisdiction. He's outside subpoena. Who knows where he is? He could be in the Bahamas. I'm not sure what you meant by that.
Well, I just meant factually. That was my understanding.
Okay.
And I agree with what Your Honor said as far as my argument on rebuttal. There's no competent substantial evidence to support the judgment. It's not a credibility determination. It's the fact that they didn't present competent substantial evidence.
Thank you.
Mr. Perkins, can I just ask you a quick question? In your view, do counts 1, 3, and 4 sort of rise and fall together, whereas count 2 is really sort of could stand on it as a separate entity?
That's exactly correct, Your Honor. 1, 3, and 4, the damages are all subsumed. They're all the same damages.
Okay.
Very good, Mr.
Thank you, Your Honor.
Perkins. And Mr. Perkins, Ms. Lynn, thank you very much. Don't forget to hit the leave button on the screen. We will take a 10-minute break and